Senate Housing and Higher Education Committees to order. Welcome, everybody. Today we'll be having an informational hearing about the Identity Dinkytown apartment building being constructed near the University of Minnesota. This building was supposed to open its doors to tenants at the end of August, but delayed construction has displaced many student renters. Those of you who followed the Higher Education Committee this past session know that housing insecurity is a pressing issue on college campuses across our state. When students don't have safe, consistent, and affordable housing, we know that they're more likely to struggle in class and more likely to drop out of school completely. When we think about making college more affordable and increasing retention rates at higher education institutions, addressing student housing issues is a key part of that puzzle. Today, we'll hear stories from some of the student renters who have been impacted. I'm grateful for the students who were able to join us today, and I want to be sure to note that we have several pieces of written testimony for students and parents in member packets. I also want to note that CA Management Services, Identity Dinkytown's property management company, has provided us with a written statement this afternoon, which you will find in the hearing materials. We are disappointed that the company has declined to participate in this conversation about this issue in a public forum. While the company has cited short notice, the short notice that they received for not being here today, I want to note that our committee staff contacted the company more than 2 weeks ago, requesting their participation in this hearing. The excuse of not having enough time to prepare is ironic considering the lack of notice that they have given to their tenants. I'm grateful for all the senators and members of the public who have made time to join us for this hearing today. We all understand the gravity of the situation for students and their families, and I look forward to a robust discussion about how we can prevent things like this from happening again in the future. And with that, I'll turn it over to my co-chair, Senator Port.
Thank you, Chair Fateh. Thank you to the public and to the students and committee members who are attending today. You know, as we hear these stories from students, I just want to reiterate that this will be highlighting today a particular concerns facing student renters, but these really are concerns that are true for renters in general and sort of put on display the imbalance of power between landlords and tenants, which is really something that my committee is focused on working to address in this next session. I'm grateful for the students who raised this issue up to us to help us understand the immediate pressures that they are under so that we can bring our attention to it. But this is also a broader issue that we look forward to focusing on this session. Our tenant landlord laws here in Minnesota are 60 or 70 years old and really have not been updated, and in some cases just no longer meet the needs of folks in our community. So again, I just want to thank the students for their advocacy, for raising this issue up to us and for bringing their stories to us today. And we look forward to continuing to partner with you as we move forward and really bring a focus to restoring a balance in landlord-tenant law coming up this next session. And now we will turn to testimony. Our first testifier is Shayna Tomanens. Shayna, if you can just introduce yourself for the record and go ahead and provide your testimony. Thank you.
Thank you to Senators Port and Senator Fateh. My name is Shayna Tomanens. I'm a staff attorney at the University of Minnesota Student Legal Services. Student Legal Services offers individualized legal representation and brief advice to University of Minnesota students at the Twin Cities campus. My areas of expertise are that of housing and consumer law. And, you know, since learning of Dinkytown's delay opening, our office has been inundated with student requests. In addition to providing individualized legal advice, we've hosted 2 different listening session, town hall style sessions for students and families. We've collaborated with city officials and stakeholders, and we've connected students with, you know, a number of resources, both on and off campus, related to mental health, food, and storage issues. In this capacity, we have served over 100 students and their families and continue to receive inquiries every day. For the past 6 weeks, the most common sentiment I hear in my office is the feeling of being deceived and the feeling of feeling stuck or that they're being held captive. Many students signed a lease to live in one of more than the 500 units at Identity Dinkytown, which is a brand new apartment complex located at the old McDonald's site in Dinkytown. Its amenities advertised for this place included parking, in-unit washer and dryer, a coffee lounge, and study rooms. Most importantly, it's really close to campus, and it was set to open before the school term started, with most leases starting either the 27th, 28th of August or the end of the month of August. Consistent with their lease, students paid their first rental payment on August 1st of this year. They found out the very next day via email on August 2nd that their place would not be ready in time. At that point, they were told that students could move in on September 15th and have recently found out that they will be moving in perhaps at the end of September or early October, and have been assured multiple times that those dates are subject to change. Students were given 2 options, and only 2 options. First, they could choose a $150 daily gift card and find their own housing. Second, they could receive an $80 gift card and be placed at a hotel that is somewhat close to campus. These options worked for some students who either had family connections or could find some place to live and receive a gift card. For some students that had a flexible school schedule and other commitments, this has worked just fine, and we've just provided advice on that issue. But for others, this is not viable, and they don't really have other choices. For example, if a student is from out of town or out of state, they had no choice other than to pick a hotel and get an $80 gift card. What I'm hearing from these students is these hotels don't have access to kitchens, they don't have a microwave, and they're told they can't use a microwave in their unit. They are told that they don't have access to parking, so they're going large distances. And there's only a single coin-operated washer and dryer for the whole hotel. Many students have academic schedules or sports schedules that are also not conducive to public transportation. 5 a.m. football practice does not work with the light rail. Students are facing additional costs and scheduling barriers related to transportation, food, and storage of their property. At best, they'll be facing a disruptive move mid-semester that affects their academics after weeks and weeks of being displaced. Now, this hardship is the product of uneven bargaining power that renters have when signing their lease. Citing lease provisions located, as you know, several pages into the lease, Identity Dinkytown has refused to release students from their leases. While there's potential legal arguments around that, and I know that there are several court cases pending, the legal process itself is not conducive to a student's schedule or to many renters' schedules. For example, a case filed on September 1 won't have its first hearing until September 14th, well into the academic year. The court process may take significant time, and remember that this is something where the court kind of tells you when you're going to come in, and they don't really care if you have class that day. Renters generally, and student renters specifically, would benefit from legislation that curtails the practice of holding students captive for months at a time while a building is being built. This is not the first time this has happened in Dinkytown in recent memory or across the state of Minnesota. Any action now will help prevent renters face future hardships and displacement. Thank you for your time.
Thank you, Ms. Jimenez. Members, do we have questions for Ms. Jimenez right at this point? Thank you very much for your testimony.
Please hold. We're going to have a technical issue be fixed on our Zoom. So one moment, please. Thank you. Next up, we have Sia Sakardande. Welcome. Please introduce yourself for the record and proceed.
Thank you. Dear Chair Fate, Chair Port, and other members of this committee, my name is Sia Sakardande, and I'm the State Coordinator for the Undergraduate Student Government at the University of Minnesota Twin Cities. What has been occurring at Identity Dinkytown over the past couple of weeks has severely impacted our campus community of students and parents. Students have been displaced and pressured to make decisions, especially tough financial decisions, to pursue options that work the best for them as they navigate this chaotic unknown. Historically, student tenants have been targeted by predatory landlords, especially by companies that are not from Minnesota, like CA Ventures. These landlords engage in practices that take advantage of students financially, which has happened in this case. The balance of power in off-campus student housing has always favored the landlord, especially because these are often first-time renters who are just hoping for a smooth transition to college and a safe space throughout the school year. Identity used their position as a landlord in this scenario to engage in predatory practices. The taking of rent before notifying the tenants that the building would not be ready was outrageous, especially because of how late in the summer students were being informed. Looking for housing in Dinkytown this late in the summer is a risky gamble, as most apartments and management companies have already filled up their units for the academic year and overpriced what they have left because of the location compared to our campus. Some students have taken on 2 leases, paying rent at both Identity and their current living situation, which is a financial burden to the already high cost of living and going to college. This blatant lack of communication is something that I've heard time and time again with every Identity tenant that I have spoken to. The lack of communication in informing students about move-in delays has occurred more than once since the initial communication. The communication about alternative housing and rent abatement was one that was spontaneous, and students were forced to respond within a week. But Identity did not choose to disclose where students would be housed if they decided to live in a hotel until closer to when students needed to be back on campus. Students were not even informed about Identity failing its temporary occupancy permit inspection. As this delay has progressed and students continue to be displaced off of campus, Identity has not been forthright and has continued to leverage the power imbalance in their favor to get away with the wrong treatment of student tenants. I believe the key in remedying this situation and to prevent this from happening in the future to other student tenants is learning from those affected about what they would like to see. As I speak with more Identity tenants, the ability to get out of this lease has been a very common ask. This is policy that the state should explore next legislative session, as being stuck in this lease has proven to be a financial and emotional drain on students. Another ask I've learned was better alternative options, as the current way of accessing the promised money in the form of gift cards has been tough on some students. Providing housing or a hotel close to campus that has the amenities that students were initially promised in their lease should have been a requirement that Identity was held to. I believe that in collaboration with student tenants and their family members who have been affected by this housing crisis, members of this committee should explore policy to provide more protections for student tenants in this situation, especially as this has not been the first time that an off-campus student housing building has not been completed by the promised move-in date on our campus. I also hope that members of this committee continue holding CA Ventures accountable and continue pushing them to make things right with their tenants, as that is the most immediate and impactful solution for those tenants. Thank you.
Thank you, Ms. Sacardande. Is there any questions for our testifier? Senator Duckworth.
Thank you, Mr. Chair. I appreciate it. Just a couple of quick ones. So would it be fair to say that you've been talking to a lot of students that have found themselves in this situation?
Yeah, I've been talking to a lot of, I'm sorry. I'm so sorry. Yeah, I have classes with a lot of student tenants. One of my roommates right now, their brother has signed on to a lease on campus. It's something that I've been on campus for like 11, 12 days, and I hear about it every single day from various students in different communities on campus. And so I keep learning more stories about students impacted by this.
Senator Duckworth.
Thank you, Mr. Chair. Are you aware of any students or families as it relates to this specific instance being able to actually get their lease voided, or is it your understanding and folks that you've been talking to that they're all being held to the terms of the lease?
Ms. Sacardande.
I've learned of one situation where a student, because of like their disability accommodations, they were able to get out of the lease because the housing options just would not work for them and their condition. But every other student I've talked to that has tried to like get out of this lease has heard no.
Okay.
Senator Duckworth.
Mr. Chair, one more, if that's okay. And I think I heard the first testifier allude to this as well, but I guess in talking to your fellow students and classmates, do you get the sense that they have any sort of certainty or comfort at all as to when they think they're going to be able to actually move into this facility, or is it very much up in the air in their opinion at this point?
Ms. Sacardande?
It's very, very much up in the air. Like, every student that I've talked to has told me a different move-in date. Like, they have heard different communications, whether it's directly talking to the landlord, whether it's talking to an attorney that they're working with. I've heard so many different dates at this point that I think that what I've been hearing is that it's just a very unknown situation, and these students are just stuck with that because the school year started, and they're just trying to get through the first couple weeks of school.
Very good. Thank you, Mr. Chair.
Thank you, Senator. Are there any other questions? Thank you, Ms. Sacardande.
Thank you.
Thank you. Our next testifier will be Wajid Suleiman. I believe is on
Hello.
Zoom.
Can you hear me fine?
Yes, now I can hear you. Please introduce your name for the record and proceed.
Okay. My name is Waj Solomon. I am a junior this year at the University of Minnesota. I'm studying computer science with a double major in statistics. This year, I signed a lease at Identity Dinkytown to be in a 5x5 unit with all of my friends. I would say that I was one of many students who signed on early to a lease, as it's common at the University of Minnesota. Once you have figured out your lease for the year that you're living in, you need to start thinking about where you're living next year. I signed my lease on October 24th, 2020, but I had been in contact since early September. I became a tenant because the apartment I was currently in, Doyle, which was also a new build, did not offer accommodations for a 5x5 unit. I wanted to be in the heart of Dinkytown because it was convenient for me getting to class and everything was brand new. Personally, I am a first-generation college student paying for my own tuition, rent, gas, and any personal expense you can think of. When I signed this lease, I knew it would cost a lot of money, but I believed that my hard work would pay off since I would have somewhere comfortable and brand new. I had speculated early on that it would not be ready, but every time I asked the leasing office, they assured me that it would be ready in time for move-in and that there was nothing to worry about. Personally, they were not convenient to me at all. Commuting to school is not ideal. Thankfully, unlike most students, I am only a 15-minute drive from campus. I live in Bloomington in the Edina Range. So I kept my complaints to myself because some students have to drive for hours or live across the country. What's more inconvenient is the amount of money being spent on gas and finding parking. Since we didn't have a time to get parking pass soon enough, all the spots were filled at the time. Another significant expense is eating. When you're waiting in between classes and don't have enough time to go home, you end up eating on campus, which adds up over time. And mind you, trying to find a parking spot on campus takes approximately 30 minutes each day. This has greatly affected my junior year. Like all other students, we create our ideal schedules in early spring following that next school year, assuming we'll be on campus. A big part of the college experience is enjoying your time on campus. Not being on campus makes me feel like I'm missing out a big part of my life, and living at home has been extremely lonely. Knowing that I'm not the only one dealing with this gives me a lot of reassurance, but it has a negative impact on your mental health. Just being able to walk to class and to socialize with people in my classes, you don't get that feeling as a commuter. It almost feels like I'm in high school, not forming a genuine connection and meaningful relationships with my peers and professors. It is also not convenient at all to move in during the middle of the school year where exams start picking up, heavier course loads, the campus traffic, and so many other factors. The leasing office was very kind to me. I don't have any negative feeling towards anyone in the office because of their kindness, but what I didn't like is that everyone seemed confused and never knew what they were talking about. There was a lot of inconsistency in the office and in the information that they provided. For example, I had an incident where I was very close in contact with the regional leasing manager when I signed my lease. She guaranteed my roommates and I a $250 gift card when we all moved in due to a special. After all of this chaos happened, we asked again about the gift cards, and someone at the leasing office told me, "You don't receive those gift cards because it was only a special for the month of May." This made absolutely no sense because they had promised this to multiple people in the fall for these gift cards. I sent them an email about this, addressing the concern, and now they have agreed to fulfill their promise. There just seemed to be a lot of incorrect information every time you called the leasing office. Everyone would give you a different response to the same question. Another incident that happened with my roommates and I is when we called them in July addressing a rumor that identity would not be ready in time and that we'd be put in hotels. I want to emphasize that this happened in late July. When we called them, they got extremely defensive and told us that the information was false and to send us the email that we received from that person. They did not seem happy at all on the phone and almost made it seem like we had made up this information, which that was not the case. I just wanted to call them and make sure that was untrue. That was an extreme red flag to me, the way that they responded. I also found it concerning that they claimed on the news and in the emails that they would update us throughout the entire office, but never told us that they failed their TCO. The city of Minneapolis confirmed this on the news, but Identity has never told or sent us an email about this, that they failed their inspection. Currently, I'm living at home with my mother in Edina, but couch hopping on the days I have my 8 a.m. labs and on the weekends. I'm contemplating on signing another lease somewhere else for a semester, but I financially cannot afford to pay both or take the risk on signing on another lease and then Identity being ready. I also think that given my financial situation, it is best for me to save those gift cards and so I have more time to focus on my studies rather than working. Some resolutions I'd like to see from the landlords, including that understanding that not everyone has the luxury of being able to figure out a last-minute plan 4 weeks before school starts. Most students living at Identity have the privilege for their parents to pay for their rent, covering a double lease or arranging a better accommodation plan for them. However, for me, and I'm sure many other students, spending the entire school year and summer working 50+ hours a week was necessary to afford something this nice. I knew when I signed this lease that it was going to be extremely expensive, but I wanted to live with my best friends in a new building with the accommodations that they promised. I diligently worked this entire summer to save up so I could afford to live here, and now this situation has arisen. The money I saved up is now going towards paying for parking ramps, metered parking, gas, and food. I believe it's only fair if we get this semester free because this has caused the biggest chaos in Dinkytown in a long time. I also wish some kind of legislation could be passed to prevent this from happening in the future. Personally, even if I have known this was going to happen, I still would have kept my lease and would have tried to figure out an alternative plan. And I'm sure many other students would have done the exact same thing. The biggest issue here is the lack of communication. I want to keep my lease and I want to live in Identity. As I have mentioned, I've worked tirelessly to live here. However, I do not find it fair at all if they expect us to move in and pay our rent for that semester and expect as nothing happened, especially if there's going to be construction happening through the first through third floor. I want to express my gratitude for you guys taking the time to listen to my statement, and I sincerely hope that my letter prompts some kind of change to prevent this happening again. Thank you.
Thank you so much for sharing your story, Ms. Solomon. Is there any questions? Senator Zainab? Mohammed.
Thank you. I have a question for you. Thank you for your testimony.
Of course.
When did Identity Dinky inform you that you would not be able to move into your unit?
They informed us on August 2nd, and we had just paid our first months of rent on August 1st.
Senator Mohammed.
Thank you, Mr. Chair. And are they still collecting rent right now, even though you're not moved in?
Ms. Solomon.
At the moment, none of us actually know what's happening because they haven't communicated that. Technically, they are supposed to be collecting rent, but I don't think, including me, I don't think anyone is actually paying that rent because it's supposed to be on some kind of rent plan, but no one knows what that actual plan is or how that is calculated.
Okay. Mr. Chair, one more follow-up.
Senator Mohammed.
And since you're living with your parents, can you sort of tell us some of the accommodations that were given to you by anybody from either the building or the owners on what to do during this time?
Ms. Solomon.
Since I opted for the $150 a day gift card, they haven't provided us any accommodations. It blatantly said in the PDF form that if you choose this option, everything is up to you and you're responsible of finding your own home and parking spot.
Senator Mohammed.
I promise this is the last one for now. So you're getting $150 gift card and I assume for you to stay at a hotel or something, and you still have no idea if you're responsible to pay for the rent at this time or not?
Ms. Solomon.
That is correct. Right now, we are just collecting the gift cards, and my plan is to save these gift cards to pay for my rent, but I don't know what's happening, especially with the gift cards expiring as well.
Thank you. Senator Port.
Thank you. You mentioned the information coming out that Identity Dinkytown failed their first temporary occupancy inspection. If they did pass the next one, how would you feel about moving in, knowing that 3 floors would still be under construction? Would you have safety concerns? Would you have concerns about, being able to stay there as a student with that construction going on? How do you feel about that?
Ms. Solomon.
My biggest concern right now is safety and how that's going to manage, especially I'm not fully understanding how they moved down rather than up to down. So I don't know how that will work with stairwells and elevators. And it's how I feel about the entire management right now is that I just can't trust them. My other concern that I had was, what if something breaks? What do we do then? Are they going to actually help us, or are they just going to say they're going to help us and then not do anything about it?
Senator
you.
Port. Thank you. And Ms. Solomon, my question to you is, the initial payment on August 1st, have you or anyone been refunded for that payment?
Absolutely not. I actually, out of all my roommates, they would say I'm the one who likes to know, but if I am putting the money that I made into something, I want to know. So I emailed them asking about that gift card, and I was just blatantly asked, where is this money going towards if it's not refunded? And they told me that it's going towards next August's rent, so that month would be free, but none of us knew that. They didn't communicate that at all.
Are there any other questions for Ms. Solomon? Thank you so much for your testimony.
Of course, thank you.
Thank you. Is Ms. Topinga available for a quick question? Thank you. Thank you, Mr. Pinga. There has been a question, and also Ms. Solomon touched on the TCO inspection. Can you provide a little bit more information about that, what happened, and if and when there will be another inspection?
Yes, Mr. Chair. I'm Katie Topinka, Director of Intergovernmental Relations for the City of Minneapolis. So there was a TCO, so that's Temporary Certificate of Occupancy inspection on August 23rd, but the city's building inspectors found that the work was not complete enough to issue a TCO. There will need to be another inspection, and the way that works is that for any building inspection, we ask that the developers or contractors contact the city when they're ready for another inspection, and then the inspectors schedule it at that time and go out and do it. So at this point, to the best of my knowledge, there is not another inspection scheduled at this time. The city will schedule one once they hear from the builders again.
And so the builders have yet not reached out to you or the city for another inspection?
Mr. Chair and committee members, they have not reached out for another inspection for the temporary certificate of occupancy. There have been a number of different types of inspections going on throughout construction related to different pieces of the work. So I can't say definitively no other inspections, but for the certificate of occupancy, my understanding is that's not scheduled at this time.
Chair Port.
Thank you, Ms. Topeka. Nice to see you. Is there a wait once they reach out to you? Is there a multiple day or week wait? I just know in my city right now, we're backed up with inspections.
Mr. Pinka.
Chair Fatah and Chair Port, I believe there can be. I can get back to the committee to let you know kind of what the waiting time is right now. I do know this is not the only building under construction in Minneapolis, and so we are being contacted regularly for requests for inspections, and so we schedule them as those requests come in.
Are there any other questions for Senator Duckworth?
Thank you, Mr. Chair. I appreciate it. I'm going to pick up where Senator Port left off. I guess in your experience as it relates to a temporary certificate of occupancy, which I'm assuming they would need to have in order to have students live there, in your experience, I guess what is the sort of turn time on getting something like that? If it happened tomorrow, is it possible if everything went well that they would get it the next day? Is it typically a week-long process? And really what I'm trying to ask on behalf of the students is it even reasonable to assume at this point, if everything went well, that they would have it by the end of this month? Because it sounds like that's something that's in question currently.
Mr. Pinka.
Mr. Chair and Senator Duckworth, I hesitate to give a definitive answer there because I'm not the building inspector, and I do believe there are situations where it can happen quickly, but sometimes there are orders that certain things need to be fixed, and then maybe they can come back the next day and do it. So I think it sort of depends on each individual situation. And this building, as has already been mentioned, is also being done in phases. And so I think I know our inspectors are working with the builders to figure out the plan around phasing and how we could do a temporary certificate of occupancy with that phasing. So I think there are instances where it can be turned around relatively quickly, but I hesitate to say that that's always the case. I know there are folks from the building trades here as well who may be able to answer that better than I can.
Senator Duckworth.
Thank you.
Senator Mohammed.
Thank you, Senator Fate. Ms. Topinka, from what it sounds like, at least from the testimony, the company had already collected the first month of rent from tenants, and they will continue to do so. Is the company permitted to collect rent from tenants without the rental license that they need?
Mr. Pinka.
Mr. Chair and Senator Mohammed, the city of Minneapolis does have a rental licensing ordinance, and a building cannot have a rental license without a certificate of occupancy. The ordinance, however, does allow for pre-leasing of units for new construction. And so I believe that's what's happened here. I'm not an attorney, and so I don't want to give anything that might be perceived as legal advice in terms of whether they are allowed to keep collecting rent. The units cannot be currently occupied because there is no rental license, but our rental licensing ordinance does have that pre-leasing exception.
Senator Mohammed.
Okay, just so I understand it correctly, they failed the initial inspection, correct? That was sort of like the bigger issue, the August 23rd one. And from my understanding, there's like something out there that says that the company will allow tenants to live in the building, the top floors 4, 5, and 6, starting September 29th. In that time frame from working at the city and sort of doing this work, do you think that's enough time for them to get this, for them to pass the inspection?
Mr. Pinka.
Mr. Chair and Senator Mohammed, I'm not really able to answer that question because I don't know enough about what work needed to be done and the plans that the contractors have in place. So I don't think I'm able to answer that question.
Okay.
Senator Mohammed.
And then one final question. So since it's a new building, because of the city's ordinance that's currently in place, they are allowed to collect money or rent from tenants, even though they don't have the proper license.
Mr. Pinka.
Mr. Chair and Senator Mohammed, I would want to probably defer or get back to you for some clarification from our city attorneys, but what I can tell you is that a building cannot obtain a rental license without a certificate of occupancy. However, for new construction, the city's rental licensing ordinance does allow a pre-leasing, and that's partly, I think, the rationale being sometimes to get projects to cash flow or to be able to have the resources they need to open. The argument is that there needs to be the ability to pre-lease units to get the financing they need. And so that's, I believe, why that exception exists in the city's ordinance. But in terms of their ability to continue collecting rent, I would need to defer to our city attorneys or an attorney on that question, I believe.
Senator Mohammed?
Okay, I think I'd sort of like to learn more about that particular ordinance that the city has and sort of what safeguards are there for issues like this sort of coming up in the future. I think it'd be important to know if somebody's building a new, property within the city and they're collecting rent or they're allowed to do that, like what safeguards we're putting in place for tenants. I think that'd be important to know because I think a lot of these young folks would not be in this particular position.
Thank you, Mr. Chair.
Senator.
Sorry, Senator Mohammed triggered a question for me. What would you say is the typical turn time to approve a rental license for a building like this? So let's say the temporary certificate of occupancy came back, it was good, and then it came for ultimate approval of a rental license. Is that something that happens fairly quickly, or can that take some time as well?
Mr. Pinka?
Mr. Chair and Senator Duckworth, I think it depends on if there's other information missing, in terms of the application. I do know we can, start to process applications, and if there's just one piece of information missing, and then that comes in, it can be turned around relatively quickly. So I think it depends on sort of if all of the other information has already been received by the city.
Senator Duckworth?
Thank you.
Thank you. Any other questions? Thank you so much, Mr. Pinka.
Thank you.
Our next testifier will be Arya Mahan Cleveland, who I believe is on Zoom.
Hi, can you hear me?
Yes, please introduce yourself for the record and proceed.
Hi, my name is Arya Mann Cleveland, and I'm a second-year transfer student at the U of M studying biology. I'm a first-time renter, signed on as a tenant with the identity at the beginning of the summer, so fairly late. When I was first speaking with the leasing office, I was told nothing about the building possibly not being ready. Instead, I was told that the building would definitely be ready and there would be a few touch-ups happening throughout move-in and the first couple of weeks of living there. At this point, I'm supposed to be living on one of the top 3 floors of the identity, meaning I'm supposed to move in on September 29th. Throughout the summer, I was working at a summer camp with limited access to Wi-Fi, so I had to juggle getting ready to move into a new school and into a new apartment at the end of August while also living at a summer camp. After weeks of preparing and paying rent, the identity shared that the building would not be ready on time. They provided us with 2 options, like shared already: live in a hotel and receive a gift card, or find your own housing and receive a gift card of a higher rate. I decided that it would be best to go with the gift card of the higher rate and commute from my house to school every day instead of living in a hotel. I drive an hour each day to and from school if I'm lucky with traffic, while also having to pay for extra gas and parking expenses. We were all told to expect a mid-September move-in date, which put the stress of moving into a new place right in the middle of classes starting. However, on September 5th, they shared that the move-in would not be able to happen mid-September, but now September 29th for only the top 3 floors. If I am able to move in at the end of September, I'll have to move into the middle of the construction site. Much of my time is spent studying, and the amenities such as study rooms will not be available at the identity, and the property managers have no information to share with us regarding a timeline of when the amenities will be ready. The construction delays and limited communication from the identity has had a very negative impact at the start of my school year. I'd have to spend a great amount of time on the road commuting to and from classes instead of using my time to study. This has added an additional layer of stress and uncertainty in my life. When talking with the property manager, I never received a straight answer to any of my questions. I was always told that they would get back to me shortly, which never happened. The construction delays may have been unpreventable, but I would like to see more accountability being taken and honesty throughout the process. Students living at the identity should have the opportunity to get out of their lease, or rent should be reduced significantly. Paying some of the top rates for an apartment that is half finished with no amenities does not make any sense to me. If I had been told about the building delays in the beginning when I signed my lease, I wouldn't have signed my lease. Thank you for listening, and I hope this was beneficial.
Thank you for sharing your story, Arya. Are there any questions for our testifier? Seeing none, we'll continue. Emmeline Goodart, are you available? I believe on Zoom.
Yes, can you hear me?
Yes, thank you so much. Please introduce yourself for the record and proceed.
Hello, my name is Emmeline Goodart. I'm in my third year at the University of Minnesota and I'm studying English. I'm one of the lucky few people who are able to get out of their lease with Identity Dinkytown. I signed a lease for a studio with Identity at the end of March 2023. I had a Pell Grant, so I qualified for the affordable housing program, and Identity offered me the best price I could find in Dinkytown. Because my family does not live in the state of Minnesota, I called monthly over the summer to check if the city had approved my lease and I would have a place to live on the 31st of August. Every time I asked, the workers at the leasing office assured me that my apartment would be ready for me on the 31st. The news that Identity Dinkytown would not be ready on time caused my parents and I to frantically search for other accommodations. I'm the child of an active duty soldier and my family currently lives in Georgia. Due to this, I had no choice but to live in a hotel provided by Identity. Despite choosing that option, my parents did not feel comfortable leaving me in Minnesota to live in a hotel room for an unknown amount of time. For nearly 2 weeks after the announcement of the delay, we still had no answer on where I would be living for the foreseeable future. My dad and I called and emailed Identity and their corporate office nearly every week in August trying to get me out of my lease. They knew of my situation. Everyone we spoke to was made aware that my family lived nowhere near Minneapolis and we were uncomfortable with the housing accommodations provided to me. Each time we were met with an "I understand, but," and "there's nothing we can do." Eventually, my parents and I planned that my dad would fly to Minneapolis and move me into Identity when the time came. Not only would they need to pay for his flights, they meaning my parents, but my parents would also need to pay longer for my storage unit. I would also need to find ways to eat without spending all the money I had saved over the summer because the hotel I was eventually placed in had no kitchenette. I'm under the impression that my lease was never finished by Identity and they sought to keep me in it anyway. A week before the 31st, I was sent additional paperwork for the affordable housing program and I discovered that my lease had never been signed by the property manager. I informed Identity of this and they still denied to let me out of my lease. Luckily, with the help of the university's student legal services and my dad's persistence, I was eventually able to get out of my lease. On the 1st of September, the day after my lease was set to start, I got an email from Identity letting me know that I had been released. This came after weeks of requesting and many no's. It was the day before my parents were meant to leave Minnesota and return to Georgia. Luckily, I now have stable housing and I'm no longer tied to Identity Dinkytown, but that does not invalidate the struggle my family and I went through. I got out on a technicality, and if not for that, I would still be in a lease with Identity today. I hope that all of those who are still in leases with Identity are able to get out of them if they wish, but I recognize that's also not an easy task. However, you can prevent a similar situation from happening again. I urge you to pass legislation that would keep anything like this from happening in the state of Minnesota from ever happening again. Students deserve to have their needs met by the landlord when something like this happens, and those needs include the option to be let out of a lease. Thank you for your time.
Thank you so much for sharing your experience, Emmeline. Is there any questions for Senator Duckworth?
Thank you, Mr. Chair. I appreciate it. And I appreciate the story shared by the testifier. I'm not sure she got out of the lease so much as she was maybe fortunate enough not to have one fully executed. My question for her is, is it your understanding that you weren't going to be held to the terms of the lease prior to August 1st, or did that happen after August 1st of this year, to the best of your recollection?
Ms. Goodart?
Yes, it's all incredibly confusing because we had very limited contact with them. In fact, I never paid rent because I was never coded in their system as a resident. I was never able to access the residence portal because my lease was left unfinished. However, it took my discovery and my lawyer through Student Legal Services discovery to recognize that my lease was incomplete and therefore I had no legal obligation. However, when we brought this to their attention, they declined many times to let me know that I had been let out of my lease.
Senator Duckworth.
Thank you, Mr. Chair. Just one quick follow-up, if that's okay. So I think you answered my follow-up question, which is, it sounds like you never paid the company any money, you never paid them any rent, therefore you didn't have the need for a refund. Is that accurate?
Ms. Goodert.
Yes, that's accurate. I was never refunded anything.
Okay.
Senator Duckworth.
Thank you, Mr. Chair.
Thank you. Senator Mohammed.
Thank you, Senator Fateh. I have three different questions, and I think for three different people. One, I want to understand from the testifier, what technical sort of, like, what's the technicality and how she got out when she said they were able to get out because of technical reasoning?
Ms. Goddard.
Yes, the technicality was that my lease was never signed by the landlord. I had signed my lease, however, they had never signed it. Therefore, it was not a binding contract because neither party, they had not signed. So therefore, both parties had not consented.
Senator Mohammed.
Thank you. And just so we understand, if the landlord at that point had signed it, then this individual would have been stuck the same way the other students would have.
Correct.
I think this might be a question for the city and Ms. Topinka. I'm sorry to bring us back to this. I want to understand what pre-leasing is. Thank you.
No worries. Thank you, Mr. Pinga. Senator Mohammed had a question. What exactly pre-leasing entails?
Mr. Chair and Senator Mohammed, my understanding, and there may be experts in the room who can explain this better than I can, but my understanding is that it's leasing out units before a building construction is complete, so that when it is complete, people can move in right away. That's the concept.
Senator Mohammed.
Thank you, Senator Fateh. And the city allows for that to happen because of the ordinance that's in place, even though the city hasn't done inspection on the property, and that company might not have the licenses that they need?
Mr. Pinka.
Mr. Chair and Senator Mohammed, yes, I will say this is a lot of cities don't have rental licenses. Some do. So the city of Minneapolis has a rental licensing system. And so I think pre-leasing is a fairly common practice for entities that are constructing new buildings so that they can have people ready to move in and generate income for the building right when it opens. My comment earlier was I believe that's why that is in our ordinance. Our rental licensing ordinance was written a number of years ago. And so as we were reviewing it recently and in discussions with the city attorney, that's our understanding of why that's likely in there is to allow for properties once they open to have that cash flow coming in right away. And so we believe that's why that's there in the ordinance.
Senator Mohammed.
One more follow-up. It might be two in one. How, out of all the properties that we have that are being built in the city, how many of this are sort of using this and pre-leasing their units before they're built? And a follow-up on that would be, is the city sort of paying attention to what happened just in Dinkytown, and are they going to take some sort of repercussion against these things? Are we going to do something about this as a city? And I think I can ask this as a Minneapolis individual.
Mr. Finga.
Mr. Chair and Senator Mohammed, I'm not sure if we know how many buildings are doing that. I can follow up with our Regulatory Services Department that runs our rental licensing system to see if they have a way to track that. I think the way they would know is if when the application comes in, there's something that signals that to them, but I'm not sure if that's something we ask in a rental licensing application. So I think it's probably safe to assume that that is a common practice, though, for new construction of rental housing. So I will follow up to see if we do have that data, but I'm not sure if we do. In terms of, the city has obviously adopted a number of different renter protection ordinances over the last 5 years or so, including source of income protection and pre-eviction filing notice and things like that. So I can't speak for our policymakers in terms of if they will be doing something specifically around this item in the rental licensing existing ordinance, but I do believe that generally renter protections are something that is a priority for our policymakers in the city.
Senator Mohammed?
This is a question for you, Senator Fateh. Is the company here?
No,
Okay.
they didn't want to show up.
And have they been invited?
Yes, 2 weeks ago, and they thought it was too short notice.
Okay, thank you.
Thank you. Thank you, Mr. Pinga. Is Ms. Goodert still on there on Zoom? I had a quick question for you, if possible. Emmeline?
Yes, I am.
Awesome, thank you. My question to you is, as a Pell eligible student, how important is affordable and consistent housing to your ability to stay in school?
I no longer qualify for the Pell Grant. I don't have one going into this year, but I did last year and the year before. I wish I still had it because it was very important to me the first 2 years being able to pay for my education. I was also under the GI Bill, which I'm no longer under anymore because I split it with my siblings. So as of this year, I was completely out on my own and I was applying for student loans for the first time. So I was intending to pay this rent with my student loans. And it was incredibly stressful because then I had taken out more money than I needed for an apartment when I had no idea when I would be moving in to this said apartment.
I understand. Thank you so much, Emmeline.
We will move on to our next testifier, Vic Thorntonson. Welcome to the committee, Mr. Thorntonson. If you would please introduce yourself for the record and provide your testimony.
Thank you, Madam Chair. My name is Vic Thorstenson. I'm the president of the Marcy Holmes Neighborhood Association in Minneapolis. This is a neighborhood association that covers the Dinkytown area. We're the most populous neighborhood in Minneapolis, and Dinkytown is the most populous census tract in the state of Minnesota. It's even more, it even has higher population density than the Cedar Riverside area of Minneapolis. It's not so dinky anymore. We expect 10,000 people in Dinkytown by the end of next year with the opening of new buildings, if they open on time. Dinkytown is truly a unique community. It's probably the one neighborhood in the entire state of Minnesota that no matter where you're from in the state of Minnesota, you're familiar with. You've either lived there, you went to school there, you've had a son or a daughter go to school there, have one in the past or in the future. Even if you didn't go to school there, you've probably, threw up on our sidewalks. It's a really well-known neighborhood, and everybody in the state of Minnesota has a stake in this 6-block area. And because of the rapid construction of housing over there, solely student housing, it used to be more of a mix. It has become more of a hotel than a neighborhood. It is, people come through, we have very rapidly, and we have a turnover rate of 50% every year in population. So it's very difficult for us as a neighborhood organization to get people involved because once they're in, they're gone for the most part. So it's one of our challenges over there. I just learned of this hearing this morning, and the thing I want to leave with you is to, once this issue with Identity Dinkytown CA Ventures is resolved, is to stay on this, because the private equity real estate firms that have taken over the housing market in student neighborhoods, both in Dinkytown, Stadium Village, and in college towns across the country, have really changed the landscape of how neighborhoods and communities are built. It used to be, going back to the familiarity of Dinkytown, that the landlords over there were people who went to the U themselves, are familiar. They actually cared a little bit about, they cared somewhat about the welfare of the students and the neighbors. These folks don't. I mean, their one priority is to their shareholders as private equity real estate firms. Second to that is their legal responsibilities, their corporate responsibilities, and down the list are the actual tenants and the neighbors themselves. So I am really pleased to learn that you have actually put together higher education and housing as an entity to look into, because this is going to be, this has been an issue for quite some time. Although a recent, mostly in the last 5 to 10 years, really. But it's going to continue to be an issue in the future. And I applaud you for breaking some new ground here on this, and I hope you stay on it. So happy to take any questions that you have.
Thank you, Mr. Thorstensen. I invite you at this point back to our committee when we're in session next year. This will certainly be something we will be talking about.
Well, I got to tell you, it's a really nice room.
I completely agree with you. There's a real concern with sort of the corporate economic priority over housing and people that we really need to take a deep look at. And having lived in Dinkytown during my time at the U, I have fond memories of the place and hardly recognize it going through, which is good in some ways. But having that priority be focused on the people involved in housing rather than just the profit involved in housing is a critical issue we need to tackle, not just in student housing, but across our state.
Unlike a lot of neighborhood groups, ours is not NIMBY. We are a pro-development, pro-density neighborhood organization, and there are real benefits to the population growth that Minneapolis has had. And I'd like to remind people that even though we grew by 50% between 2010 and 2020, all we did in that was equal the population that we had in 1950. And there were no high-rises there, or basically it was all rooming houses and people renting on spare bedrooms and homes. And that was the community of Dinkytown. And it'll never go back to that. But it would be nice to build more permanent housing. The problem with student-only housing is that it doesn't have any consideration for part-time students, for occasional students like I was, who go to school, have to leave to go to work for a while to earn some money and then go back to school. These buildings have no accommodation for that at all. You're either in for a semester and then you're out. So thanks again for putting this together, and we'll be following it very closely.
Thank you, Mr. Thorstensen. Members, do you have any other questions for the testifier? Senator Bolden, I think you have your hand up.
I do. Thank you, Chair Port. I just wanted to thank the testifier for his comments and just sort of reiterate my desire to continue talking about this issue, and specifically the sort of effect of corporations on housing in general. And certainly we're hearing today what that looks like for student housing, but that has an effect of housing broadly across the state. And as our committee has had some conversation about that, and I look forward to continuing that conversation about how the effect corporations coming in and buying up single family homes and changing those into rental properties, what that means for communities and what that means for Minnesotans. And so I think it's clear we have more work to do in that space. Thank you.
Thank you, Senator Bolden. Next, we will have Dan McConnell from the Minnesota State Building Trade Council.
Senator Lucero had a question.
Oh, I'm sorry, Senator Lucero, you have your hand up.
Thank you, Madam Chair. Just a quick question in regards to Senator Bolden there. Was this, what we're discussing here, is this single family homes, the nature of the housing type that we're discussing today?
It is not. Senator Bolden, do you want to jump in? Mr. Thorstensen?
Madam Chair, Senator Lucero, what we're seeing in our neighborhood are single-family homes being torn down for apartment buildings. And this community used to have an elementary school and 2 high schools. Now they have neither of those things. And the last time we took a look, which was, I believe, in the spring of this year, we counted 4 single-family homes in all of this neighborhood. That's all that's left. And what were there have been torn down, and they've been turned into rental housing.
Thank you, Mr. Thorstensen. Senator Bolden, did you have a response as well?
I would just, thank you, Madam Chair. I would just add, I wasn't inferring that the topic today was around single-family homes. I just was making the connection of, you know, the actors, if you will, the corporations who are serving as landlords and the effect that has on Minnesotans and, you know, the work that means for our committee.
Thank you. Senator Lucero, do you have a follow-up?
Thank you. So to the testifier then, he mentioned the tearing down of single-family homes in the building then, or tearing down of schools, or schools and single-family homes being replaced by different forms of housing. Is that guided by local zoning ordinances and planning commissions and such in order to allow for such to happen, or is that governed at the state level?
Mr. Thorstensen?
Mostly it's Senator Lucero, I would say most of it is simply homeowner passing away and the children selling off the home to a developer is probably the most common path for that. But the rules that they're operating under are not the 2040 plan that people have heard about. These actually were rules that have been in place for quite a while in that neighborhood for many years.
Senator Lucero, do you have a follow-up?
Yeah, thank you, Madam Chair. And I just want to highlight that there's a lot of different issues, and I very much appreciate both chairs, the members of this, both committees, the being a member of this, of the Housing Committee, and I appreciate the students coming in and sharing their unfortunate experience. But there are a number of issues that are obviously contributing factors from a myriad of things. And I just want committee members and everybody that might be listening to understand that this is a very complex issue with very, very high number of moving parts. So when we discuss, for example, when somebody throws out, well, schools and single family homes are being replaced by different types of buildings, that's not state level guidance that's happening there. That is local, and you can't just replace a single family home with a commercial building. That is a local zoning issue that requires permission from local authorities. And so I'm always cautious when I hear a bunch of statements thrown out there that may or may not necessarily be true, or there are other variables that factor into it. Additionally, in the previous conversation, there was a discussion on pre-leasing. Pre-leasing, I suspect, is more guided by much financing, much as the case is with new construction to any other form, not just apartments or multi-living types of commercial buildings. So when it comes to financing, lending institutions, they accept a lease agreement or some kind of contract in order to qualify for financing in order to build. So in the construction of a single family home, many times builders won't build that unless there is some kind of a purchase agreement or other kind of contract that has been signed in order to move forward with any kind of construction project and or to present to a lender to get and secure financing. In this case, as the Minneapolis official was referencing pre-leasing, I highly suspect that it's mostly, or at least heavily influenced by demonstrating to the demand and demonstrating to a lender that, hey, there are leases on this. And it, again, helps to attract such financing of multi-million-dollar construction projects. But again, many moving parts. Thank you, Madam Chair.
Thank you, Senator Lucero. Thank you, Mr. Thorstensen. Mr. McConnell. Welcome to the committee. Please introduce yourself for the record and provide your testimony.
Thank you, Madam Chair and Senators, for having this hearing. While I recognize this is not a labor inquiry, I do believe that there are some labor issues that are relevant to why this project is so far behind schedule. And I do just want to take a minute to thank the members here for enacting wage theft protections in previous sessions and the general contractor liability, which will hopefully curb some of the things we're seeing on this job. I would just want to say this project is, in my opinion, a black eye on the construction industry. I just give a little bit of history on this project from my perspective. In 2017, we became aware of this project being proposed. Immediately reached out to the developer to try and determine who they would be using for the construction. Obviously, as a representative of the construction workers in the state of Minnesota, we're interested in who's going to do the work. We also were aware of concerns on a previous project done by this developer just down the street, where we had concerns around labor violations. So we were very eager to talk to this developer about their plans for this project. Also in 2017, we had another project on campus. I think one of the previous testifiers alluded to was Prime Place or Arrow Apartments that had a similar outcome where they were months behind schedule and students were displaced. There's extensive coverage on that in Minnesota Daily. If you Google Prime Place Apartments, you'll find plenty to read about there. And on that project, we had concerns with late delivery, their labor practices on that project, and poor quality construction. I guess one of the things we learned from that project is that students should not be moved into a project until the project is safe, right? And I hope that everyone's can agree on that here. In the Prime Place project, we saw students that were moved in before the units were clean, and subsequently students complained to us and others about respiratory issues because it was so dirty. There was fiberglass insulation blowing around the units. They developed respiratory issues. We hired a consultant to go in and sample the air. We determined all the furnace filters were plugged because they were brand new units, but during the construction and they're running them and they got plugged up. So I would hope that before students are moved into this project that we make sure that the project's done, it's safe, the units are clean. So as I said, I reached out to the developer in 2018, 2019, 2020. We finally connected with them. 2021, they told us they were looking at using a local contractor, Kraus Anderson. Kraus Anderson really didn't know anything about it. They did a quick look at the project, but didn't have substantial conversation with them. Later in 2021, we were told Catalyst was awarded the project. We met with Catalyst in July of 21. We sent them a list of local subcontractors that they could use for this project, and we never heard back. Over the course of the construction, the affiliates of the Minneapolis Building Trades have visited the project multiple times. We've had reports of workers not being paid for hours worked, including overtime pay. We've had reports of workers being paid in cash without withholding taxes deducted for their wages. We're aware that Minnesota OSHA is investigating numerous safety violations. And I also want to point out the questions about the certificate of occupancy and the inspections by the city of Minneapolis. I also want to point out that there are two scopes of work, or at least two scopes of work, that Minnesota Department of Labor and Industry is responsible for. That's electrical inspections and elevator inspections are under the jurisdiction of the Minnesota Department of Labor and Industry. There are currently open permits that I was able to find for elevator and fire alarm. I was able to find the electrical permit. There's often multiple addresses associated with the project, and I didn't have time to track that one down. But assuming that there's a permit for electrical too, that's probably not done based on the status of the project. I would say that, or I would like to share that until the city can't issue the certificate of occupancy until the state discharges those permits as well, right, or finalizes those permits. So I want to check in with the Department of Labor and Industry as well on what they know about this project. I think they're well aware of what's going on there. Also, I just share that a personal friend of mine, son signed a lease there on the same story we've heard before on 8/1. On 8/2, or 8/1, they made payment. On 8/2, they were informed they couldn't move in. You know, I could tell you, like, I've spent 25 years in the construction industry as a professional, and many years before that as an amateur in the industry. But I will tell you, like, I drove by that project daily. It's right on my way between my office and my house, right? And we have had many affiliates, as I mentioned. Many of our reps have been on that job. We knew late July that this wasn't going to be even close, and I can't imagine that the developer or the contractor didn't know months in advance, right? I mean, typically on a construction project, whether you go onto a job trailer or a project office, you'll see a large piece of paper with the schedule, right? And the end day is the most important day on that schedule, right? The day that thing is supposed to open. And there's benchmarks backing up from that all the way to the day they started the project. There's no way they didn't know months ahead of time. Haven't seen that schedule, but I can't imagine there's not lots of highlights, red marks, notes on that schedule of missed dates and missed benchmarks. The developer, their claim to me is ludicrous, right? In my experience, there are weekly check-ins with the owner and the contractor, progress meetings, they call them. And I can't imagine they didn't know. I would guess some of the questions I would ask, did the developer and the general contractor communicate with their subs in ways and they know that they weren't going to make it, like asking about their schedule? I would suggest that. Are they making claims that their cost overruns? We have had shortages of supplies, right? Supply chain issues have been a very timely topic. I'm not aware of any on this project, but I don't think they're making that claim here, right? I haven't heard them say that, but that's a good question we should ask. And why did the developer insist on collecting rent? Did they cash flow this, like to pay the contractors? I mean, I think there's a lot of conversation I heard with the previous testifiers around pre-leasing and the need to, get financing for a project. I think that's true that you need to get a certain number of units sold on a condo project before you can finance a project. I don't believe that's true on an apartment project. I mean, typically on an apartment project, you start leasing, right, as early as you can, right? You want to fill those units, right? You want to have predictability, and I think the people moving want to, need to give notice to where they're moving from. They need to make those arrangements. They need to rent a truck. They need to, we heard testifiers talk about have their family members come and help them move. I mean, all those things, right? You can't just wait until the project's done and then move in. I think pre-leasing is appropriate, but I think there should be, maybe some guidelines around that, right? Like if you don't make the date, there needs to be a remedy, right? Because it's a huge inconvenience, to say the least, for all these folks. So that's my testimony. Thank you, Madam Chair, and committee members. Happy to answer any questions.
Thank you, Mr. McConnell. I have a couple of questions for you. As you were talking about that planned out schedule that I'm sure exists on a project of this size, in your experience in the construction industry, once you sort of get to that point where you, as a project manager or as a company, think you're ready for the electrical inspection, the elevator inspection, all of those, not to mention the occupancy inspection. Once you get to that point, what is common in the industry to sort of expect for timeline to getting through all of those and getting to that final point?
Well, I mean, I think the representative from Minneapolis, to Mr. Pinka's point, I think if you're ready for the inspection, it's not that hard to pass. If you're not ready for the inspection takes a lot longer and it gets documented. More documents and more corrective orders are issued, right? So, ideally, it would be a pretty quick process, right? You would have good communication with your inspector. The inspector would have a schedule. They know when your due date is. They would have kind of a plan mapped out ahead of time where they would plan on, okay, you need a CO on this date. I need to see these things. Your inspector would work with you on ensuring those things are happening. It's typically what I would see. So I would think a lot of people knew a lot ahead of time that this wasn't going to get done.
Thank you. Members, do we have other questions for the testifier? Senator Mohammed.
Maybe this is for clarity. You, I think, said something along the lines of the company would have known that the unit wouldn't have been available months before the students got the notice on August 2nd.
It is unimaginable to me that they wouldn't have known.
Okay. So is it safe to say the students should have gotten a notice before even paying the rent on August 1st? And has that happened before, considering you've been in this work for 20 years and more?
I would think that's incredibly reasonable to expect that that would happen, yes. That they would have known months ahead and they could have given advance notice. I would think that, I mean, if you're that far behind, you can't, I mean, typically if you're a little bit behind, you see increased work hours, right? Overtime, maybe a second shift put on, things like that to try and finish the project. Like, I mean, we're hearing from, just, I don't want to share rumors, but we're hearing November, this thing might be done. So, I mean, you can't be 3 months behind and not know it.
Okay, thank you. And
Senator Mohammed.
thank you, Senator Port, or Chair Port. I hope that the company didn't collect rent, knowing that they had known this and withheld it from the tenants. From the time, you've been doing this for a long time, from your experience over the years, has this happened before to, in any other, in any other place with you have seen places get built, tenants have leased already units, and then they wouldn't be ready in time? And can you sort of walk us through what that time frame of when the tenants would know versus what the company would know would be, and what that has been like?
Mr. McConnell.
Thank you, thank you, Senator, Madam Chair, and Senator Mohammed. I'm not an expert on leasing and occupancy of units. I'll just say in my personal experience, I'm aware the Prime Place apartments missed their deadline, right? Professionally, I'm aware of that. I know that I was on a project that we missed the deadline by a couple days, right? And there was hell to pay for that, right? Like just for a couple days. And it happens, right? I mean, it'll happen. Typically, it's only a couple days. I've never seen a project this far behind than where they've, had people pay their leases.
Thank you. Thank you, Mr. McConnell.
Thank you, Madam Chair.
The last testifier we have signed up is Larry McDonough. Oh, Senator Umu Verbaeten, you have your hand up?
Hi, thank you. I had a question for Mr. McConnell if he's still in the building.
He is. Go ahead, Senator Umu Verbaeten.
Thank you. Mr. McConnell, I think you alluded to just some of the concerns with with CA Ventures and previous projects. And then, of course, in your role, ensuring that workers are, treated fairly and that local folks are the ones doing the work on these projects. So did you have any concerns in this project specifically with how the workers were treated?
Yes.
Mr. McConnell.
Madam Chair and Senator, yes, I do. I think I testified about that. We believe that people are not being paid appropriately on this job. We believe that there are child labor violations on this job, and we believe there are numerous safety violations on this job.
And
Senator
can I
Umu
ask a
Verbaeten.
follow-up question?
Go ahead.
Thank you, Madam Chair. And Mr. McConnell, are you worried about any workers being misclassified as well as like independent contractors?
Yeah, I'm not aware, sorry.
Mr. McConnell, go ahead.
Thank you, Madam Chair and Senator Verbaeten. I'm not aware of the status of the workers. I haven't been on this job myself, but I would say it's reasonable to expect that we see that a lot on projects like this with wage theft, labor trafficking, concerns where contractors are misclassified. To me, those three terms are all kind of like somewhat related to each other, right? And there's a lot of connection between those terms.
Senator Umu Verbaeten.
Thank you.
Okay,
Thank you, Mr. McConnell. We'll move to our final testifier on the list, Larry McDonough, who I believe is joining us online.
Yes, thank you, Madam Chair.
Larry,
my name
please
is Larry
introduce
McDonough.
yourself. Yep, and go ahead and provide your testimony.
Yes. And my name's Larry McDonough. I'm a policy attorney at Homeline, and I have about 40 years of experience practicing landlord-tenant law. And my job at Homeline, one of my jobs at Homeline, is to look at all the different landlord-tenant laws in Minnesota and to see where there are imbalances and to propose legislation on them. So most of my work has been advocating for tenants, but I'm also a former landlord. I was a landlord off and on for about 30 years. And I definitely connect with the plight of the students. I was a student at the University of Minnesota a long time ago in the 70s. I was a music major. That's kind of my other life. And when I came to campus, I needed to come to campus early for outdoor marching band practice, and also to run on the cross-country and track teams. And so I know if I'd been in this situation, I would have been in quite a pickle trying to do those things and make housing arrangements. So getting to landlord-tenant laws, Senator Port, you're correct that many of our laws are quite old. Our first laws go back to 1851. And the modern era of landlord-tenant laws starts in 1971. And the statutes related to lockouts and exclusions date back to 1975 with very little changes to them since then. And so they've been on kind of my target to look at modernizing those. And part of what's going on here shows us some of the imbalances that there are in landlord-tenant law. Some, but not all landlords believe they don't have to honor the start date, and the tenants just have to do what they do to deal with that. At the same time, state law doesn't allow a tenant to get out of a lease for loss of income. Now, there are three statutes that are kind of relevant to what we're discussing today. And unfortunately, they're not clear because they haven't been updated in a long time. So one's 504B.225. It makes unlawfully removing or excluding a tenant a misdemeanor. So part of the problem here is was this unlawful or not? The landlord has a provision in their lease saying that if they're not ready in time, essentially tough. And so it raises the legal argument as to whether they unlawfully excluded tenants or not. So they may have committed a misdemeanor, they might not have. 504B.231 applies when a landlord or people acting on the landlord's behalf unlawfully, again, we have that word unlawfully, but we also have another phrase, and in bad faith removes, excludes, or forcibly keeps a tenant out. And all it says is the tenant can recover treble damages or $500, whichever is greater, and reasonable attorney's fees. So neither of these laws clearly apply to a landlord making statements of an intention to remove or exclude a tenant. And so there's an argument that the landlord hasn't violated either of these statutes until the landlord actually excludes the tenant. Neither of these laws allow the tenant to rescind the lease without going to court, and neither of them would require a landlord to house a tenant elsewhere if the unit's unavailable. Now, there's another law, 504B.375, and that allows a tenant to sue to regain possession of the property when the tenant's been excluded. But again, it does not clearly apply to the landlord making statements of an intention to remove or exclude a tenant. So it's not clear that the tenant could sue until they've actually been excluded. And essentially the action is to, if the tenant's been excluded from the apartment, to force the landlord to let the tenant back into that apartment. That law also does not provide for rescinding the lease and doesn't say anything about forcing the landlord to house the tenant elsewhere if the unit's not available. So I think there are areas where this committee could be active in reviewing these laws, specifically looking at removing some of the qualifying language, like the use of the word unlawfully and in bad faith, to clearly apply it to statements of an intention to remove or exclude a tenant, to allow a tenant to rescind the lease and get the money back without having to sue, to require the landlord to house the tenant elsewhere if a unit's not available, and increase the damages for violations. There were some questions earlier about where does rental licensing kind of fit with all this. The Minneapolis ordinance does say that it's unlawful to rent out a unit in violation of the ordinance. And there have been a number of court decisions that have said, well, if it's unlawful to rent it out, it's unlawful to collect rent as well. But there aren't any kind of binding decisions from the Minnesota Supreme Court on that. And Minnesota has no statute discussing remedies when landlords violate rental licensing ordinances. So that would be another area where this committee could look at a new law. I'm happy to work with the committee on bills and happy to take any questions that you might have.
Thank you, Mr. McDonough. Members, any questions for Mr. McDonough? Chair Fate.
Thank you so much for your testimony. I have in front of me a sample lease from Identity Dinkytown, and I'm a little concerned that some of the other provisions seem to go around the importance landlord-tenant laws that renters had specifically in the past organized to get passed. On the first page of the lease, it says it begins August 31st, 2023, and ends on August 16th, 2024, for a term of roughly 11 and a half months. But the tenant is charged for the full 12 months of rent without proration for the final half month. 504B.116 requires landlords to prorate the final month's rent when a lease ends before the last day of the final month. And to us, this clearly undermines what protections were written into law in the past when student advocates pushed for it. We know that the reason this law exists in the first place was largely because large companies near campuses were charging the full 12 months of rent, and despite making folks move out partway through the last month. Identity Dinkytown is also already charging their tenants for a service that they aren't receiving by refusing to refund their first month's rent, and they're effectively doing so in the final month as well, charging for a term in which the renters or the tenants are not occupying. So I guess my question is there any other buildings or situations that you've seen this in practice?
Mr. McDonough. Mr. McDonough.
Chair Fate, thank you. My practice is not as connected to the university campus as the University of Minnesota Student Legal Services, so I think that probably would be better answered there. But I think what we're seeing here is part of a larger problem, and I think that's part of the problem that Senator Bolton was discussing, is that we have large corporate landlord and housing operations coming into Minnesota, and they're essentially trying to take a practice that they use elsewhere in the country and just impose it here, regardless of the laws. I saw a case in the last couple of years down in the Northfield area where a manufactured home park owner, a new corporate owner, was doing all kinds of things that were violating Minnesota statutes until the Attorney General's office got involved, and then they backed off. So, but the reference to 116, I think, is another good topic for us to discuss, 504B 116, because we have a lot of laws in Minnesota that put obligations on landlords and tenants, but don't say very much about what happens if a landlord or tenant violates that law. And so 504B 116 has an obligation there to prorate, applies to all leases, says landlords can't waive it. Any attempt to waive it's unenforceable, but then doesn't say, so what happens then? And I think that quite a few of our laws are missing that component of saying, for instance, if I drive 60 miles an hour in a school zone, there's a law, and there's a ramification to that. And quite a few of our statutes in 504B don't have that. Like, what is the remedy? Is the remedy to get out of the lease? Is the remedy to have a dollar amount for a violation? And this is something that I've seen throughout 504B.
Thank you, Mr. McDonough. Ms. Jimenez, would you be willing to come up and answer Senator Fate's question? Thank you. Ms. Jimenez.
Thank you, Senators Port, Senator Pate. So in my scope at the University of Minnesota Student Legal Service, my practice is only student renting. And I always want to clarify that people don't come to student legal services generally when they're working well with their landlord and when they don't have problems with their landlord. So I only see the bad cases. I will say disproportionately corporate out-of-town landlords use a form lease very similar to this lease that do charge for 12 months and have people leave out mid-month. Our office vigilantly, both tell students proactively, like, hey, you should know you have rights under this. Maybe don't sign at this place. We also, on the back end, try to inform landlords. I would say I have not personally, nor has anyone in my office successfully had a corporate out-of-town landlord change their lease.
Thank you, Ms. Jimenez. Senator Umu Verbatim, I think you have a question?
Yes, and my question was for Mr. McDonough. I think he's still with us online. I just wanted to, thank you, Madam Chair. Mr. McDonough, I just wanted to clarify, you were talking about the remedies that are needed, but it sounded like also the enforcement. So just as we're looking to ensure that this doesn't happen to students in the future, is there confusion not just around specific remedies that we should put in there, but that it is enforced and who it is enforced by? Just wanting to clarify if that was what you were alluding to, and then just if you can remind us what some of those suggestions are that you have for our committee.
Mr. McDonough.
Yeah, thank you, Senator Umar Verbatim. So the things that aren't clear is that do these laws apply when a landlord says, I'm essentially going to exclude you? Because all the laws really seem to talk more about in the past tense, like I've been excluded, now here's my remedy, okay? So that was part of the problem here, is that tenants were being told they're gonna be excluded, but the law is gray as to what could be done before they were actually excluded, okay? So I think the laws should be applied to those statements of an intent to exclude in addition to the actual past tense exclusion. Okay, so that's one thing. The other problems we have are these qualifying words, unlawfully excluding or excluding in bad faith. Well, landlord could say, well, I've got this in my lease and, it's kind of not my fault that things didn't happen as fast. So then that kind of raises the question, when you have those qualifying words in there, does a particular type of exclusion is it actionable or not? Another problem is that these laws, as they sit right now, really require a tenant to sue over it. And as you heard earlier, that was certainly problematic. I can certainly tell you that when I was a first-year music student at the University of Minnesota, the idea that I was gonna spend time away from marching band suing to get some sort of remedy here was probably, I can tell you, it wasn't gonna happen. And so having something that allows a tenant to essentially unilaterally respond to this, because a number of tenants wanted to just say, okay, I'm done. I want to just rescind my lease. The laws ought to allow that. Right now, the laws are pretty gray on that. My conservative advice to a tenant would be is that you need to sue in order to get the rescission. But even our laws that talk about suing after you've been locked out are really more geared at getting into the unit from which you've been excluded. They don't say specifically that you could rescind. They also don't say specifically that if the unit's not available, that the landlord would have an obligation to put you somewhere else. And so those are a number of the things that I mentioned earlier. I'd be happy to present some proposed language or a memo that discusses these concepts in any way that I can be helpful.
Thank you, Mr. McDonough. Senator Umer Verbatim, any follow-up?
No, thank you, Madam Chair.
Thank you. Senator Fateh.
Thank you. This is for Mr. McDonough or Ms. Tominez, either or. On page 2 of the lease, it reads, landlord has the right to relocate tenant to another bedroom and or unit of comparable floor plan, style, bedroom type, and level if available. The tenant acknowledges and agree that landlord cannot guarantee a comparable bedroom, unit, or type. And going back to 504B, there's a requirement that buildings with 12 or more units must have a written lease for a specific unit and not just an unspecified lease for a bedroom in the unit or building as a whole. For a landlord to waive this protection and essentially reserve the right to place any tenant in any unit that for any reason, it seems to create an imbalance of power. Can you tell me whether you believe this statute is waivable by the landlord and tenant?
Ms. Jimenez.
Thank you, Senator Fateh, Senator Port. So that's one of the most litigated areas in my office that we see are when you're talking about places that have, you're renting a bed or a bedroom, one of 5. Sometimes there's interpersonal conflict, which is what I think maybe some landlords are looking to do, that if one person is particularly unstudious and is causing a lot of problems, maybe they move them to a different 5-unit one where they could have better, friends to be around. Unfortunately, it's also used in other areas, such as we had buildings both this spring and this summer where entire floors were flooded, and rather than rehouse them in another place or another comparable building, if they own multiple buildings in Dinkytown, they said, oh, we can just move you whenever we want. So we're going to move you to this place that doesn't have the same layout, that if you would have paid rent there would have been less rent, and we can do that under this lease. Our litigation position is obviously different than that, and we take these cases sometimes, but most students, one, don't want to contact our office. There's a lot of fear there. And when they do contact our office and I explain what the litigation process looks like and what we can do, they say, oh, no, thank you, I can't afford a filing fee. I don't qualify for a fee waiver at the court. I don't have time, energy, resources to do that sort of case. And so it's just a real case of a power imbalance throughout the process while someone's being displaced.
Senator Fateh.
Good. Thank you so much.
Thank you very much, Ms. Jimenez.
Mr. McDonough had his hand raised. Mr. McDonough?
Mr. McDonough?
Thank you, Chair Port. 504B 111 doesn't have, in my view, a very usable remedy. Essentially, if the landlord violates that law, all it says is that the landlord's guilty of a petty misdemeanor. So that would be like a traffic ticket. There isn't anything in there that says that the statute cannot be waived. We have other statutes that say that. This one doesn't have it. And also doesn't have any remedy in there that would allow, for instance, the tenant to, again, rescind the lease. So I think what we're highlighting here is, and I thank the senators for pointing out these different statutes, is where there's just more evidence of imbalances. And it's nothing against the authors of these statutes. I mean, sometimes the statute's written for a specific purpose with some specific fact pattern involved, and it only kind of becomes more obvious as time passes that a particular law, it has some weaknesses in it from an enforceability standpoint, from a coverage standpoint, from an ability of people to ignore it. And so this would be another one that could use some remedy additions to it.
Thank you, Mr. McDonough. Members, any final conversation, questions? Senator Duckworth.
Thank you, Madam Chair. I appreciate it. And big thanks to everybody that came and testified today and provided information. I just have a quick comment. It's not a question. I guess I'm not prepared to debate all of our statutes as it relates to landlords, tenants, what have you, but I think this is a pretty common sense example of something that I think we all view as wrong and how it played out. That's my personal opinion. I don't think collecting rent the day before you let folks know it's not going to be available is obviously the right thing to do. And so specific to this instance, as we look at state statute, whether we have discussions regarding timely disclosure or fair and timely recourse on the part of a tenant, I think that makes sense. I'll stop short of saying, we need to rewrite everything. I think the courts oftentimes are called upon to remedy these situations. But in terms of next session, looking at how we could help avoid this or get people information in a much more timely manner would be wise. There's a letter that we received. It's dated September 13th, 2023, in which the person says they became aware of an 8-week winter shutdown regarding the construction due to a lack of funds. So they're not here. I can't ask them when they found out about that or what have you. But, cases of force majeure are one thing. But if folks are aware of the fact that they're going to be missing timelines and not accurately or timely communicating that, I could see as a very significant issue that we might be able to address. So thank you.
Thank you, Senator Duckworth. Members, any other statements? I will just add, Senator Duckworth, I agree with you completely. If in what feels like a pretty egregious situation, an example here in front of us, the legal remedies are still in question, I think that means that we have a responsibility at the legislature to take a look. We certainly, Chair Fate and I certainly agree that this is going to be a priority for us going into next session. We are committed to ensuring that renters and tenants, whether they're students or not, are treated equally and fairly in our housing system. And we'll be exploring, new legislation to ensure that every Minnesotan has a safe and stable place to call home. I do want to thank, on behalf of Senator Fate and I, all the testifiers today who came, shared your stories, and helped us understand this issue more completely. Also, a thank you to our committee members and staff who came in during the interim to address this issue in a timely manner. We thank you very much for your time, and at that, we are adjourned.